Yes.
My lords, my lady, we were looking yesterday afternoon at the case of Mandler, and there's just one short further passage that I would like to emphasise. This is in the Authorities, Volume 4, tab 35. Page 564.
Tab 35, you say?
Tab 35, page 564. Lord Fraser here sets out two key passages from the judgments of the New Zealand Court of Appeal in King Ansell and approves them. The first is just opposite the letter B. The real test is whether the individuals or the group regard themselves and are regarded by others in the community as having a particular historical identity in terms of their colour or their racial, national or ethnic origins. That must be based on a belief shared by members of the group. And I lay stress on that because when one is looking from the perception of the discriminator and ask, is this person a member of the group based on a belief shared by the group about a shared historical identity, we submit that you cannot put a razor blade between that and the test that is actually being applied by the OCR in determining Jewish status. And then the next passage immediately below, a group's identifiable in terms of its ethnic origins if it's a segment of the population distinguished from others by a sufficient combination of shared customs, belief traditions, and characteristics derived from a common or presumed common past, even if not drawn from what in biological terms is a common racial stock. Now, obviously, the common racial stock is a fortiori. If there is a common racial stock, then you will be in. But it's saying even if there is not, that these characteristics will suffice. It's that combination which gives them an historically determined social identity in their own eyes and in the eyes of those outside the group. They have a distinct social identity based not simply on group cohesion and solidarity, but also on their belief as to their historical antecedents. And again, I stress that passage.
I mean, your proposition amounts to this, that any religion which defined its membership by reference to blood would axiomatically be defining an ethnic entity, is it? Or itself?
I don't go quite so far as that, because, first of all, the religion, the members of the religion must be seen as a sufficiently cohesive group with these characteristics also to be an ethnic group. So, for example, if you compare this with Muslims, a Muslim child, a child of a Muslim father is regarded as a Muslim. But Islam is a worldwide faith with many, many different ethnic groups and no overall ethnic cohesive identity. But here you start from the proposition that the Jews are a people who see themselves as having a common history and a common past. They see themselves, whether it's true or not, no one can say, but they see themselves explicitly as the descendants of the children of Israel who gathered at the foot of Mount Sinai to receive the Ten Commandments. That is the origin of the Jewish concept of self-identity. So we have this notion of a belief as to historical antecedents. And then you combine that with the self-definition through belief, through religious belief, of who is in and who is out of the group. And my submission is that when you start with that definition of the group, and where the religious belief is so intimately a part of that group's concept of self, if you ask what is the Jewish religion, the answer is it is the religion of the Jewish people. And once those two concepts are so closely intertwined, then in my submission, you simply can't detach the inherited Jewish status from the notion of ethnic origins, because in substance, the question that the Chief Rabbi is asking is this person a member of our ethnic group, defined by our beliefs and our presumed historical antecedents?
So what is he asking himself?
Is this person a member of our ethnic group, in substance, defined by our beliefs and our presumed historical antecedents? I'm going to show your lordships and your ladyship in a minute the actual task that's carried out when this question is investigated, and we'll see what it entails. But one has to, of course, read these passages together with the earlier passages that we looked at yesterday from Lord Fraser, where he identified the fact that converts could be included. So the group includes those who are recognised by the group as being converted into it. That doesn't stop it being an ethnic group.
Ms. Rose, yesterday, at an early stage, and I think it's in your written case as well, you stress, and for obvious reasons, that you're not saying that Judaism is racist.
Yes.
The difficulty I have is that the school here follows the test, which is a test laid down by, it happens to be the Orthodox rabbi, but it could be the Masorti, it doesn't matter which. And the moment they apply that test, and there's no suggestion they're doing it in other than in good faith and so on and so forth, you say the result is racist. Now, how do these two propositions stand together?
They stand together in this way. Racist is a shorthand term for racially discriminatory. There is nothing racist about a group defining itself in terms of its ethnic or racial origin. I might say, I am British. It's not racist for me to say I'm British. What becomes racist is if you make access to particular benefits dependent on the possession of a particular racial trait. So it's not racist for me to say I'm British any more than it is for the Jewish community to say those whom we recognise as part of our historically derived community are Jews. What then becomes racially discriminatory or racist in the broadest sense is if you then use that criterion as the condition for access to a school place. That's the distinction that I seek to draw. I say there's no objection at all to the Jewish community worshipping as a group, organising itself as a group, taking advantage of the specific statutory exceptions in the Race Relations Act that are designed to enable it to do that. The objection is simply to it using its ethnically based self-definition for access to a school place.
Are you entitled to take the context in which the exercise is being carried out into account? The context here is education, but we've got various other examples in play of where exactly the same point might be asked. Is this person, is this individual who we contemplate a member of the Jewish religion?
Yes.
Now, of course, you say inevitably that brings in the ethnic question, but membership is the badge that needs to be shown, and can one say, well, if you're asking is it really racist, you look at the context and look at the question as to whether it really is intended to distinguish people because of ethnicity alone, or even predominantly, or because religion tells you there is no escape from this. This is simply what the religion tells you.
Well, no, I would not say that's the correct approach, because that takes you back to the motive issue. Why context is sensitive and really, in my submission, what that is about is justification. That there will be some circumstances in which the fact that you are operating under a religious rule will give you a defence under the statute. But there's no general defence of justification to direct discrimination. There's only a defence if it's specifically provided for in the Race Relations Act. So to take an example, a Jewish charity. Somebody leaves money for a charity for the care of elderly Jewish people. And access to the care home is on the basis of being recognised as Jewish. And that's a charity established by the Jews as an ethnic group to care for their own, in their own care homes. And in those homes, the elderly people will receive kosher food. They'll have people coming in, rabbis coming in, and so on. Absolutely lawful, absolutely fine, because that's a community providing its services for itself through its own charity. Fine. So that in that sense, Parliament has determined that that context is acceptable.
Well, there's an exception for that.
Yes, and my point is that that reflects the underlying legislative policy, that in that context, to make the distinction based on ethnicity is acceptable. And if you look at that exception, charities are fine so long as they don't distinguish on the basis of colour. Yeah. So you couldn't have a care home for only white people, but you can have a care home for only Jews. But there is no statutory exception for education. And I'm going to show the court in a minute
Well,
the mass of the international law instruments which stress the importance in terms of the welfare of the child of access to education.
Well, you really identify the point that's concerning me. You say there's no statutory exception for education.
Yes.
But Lord Panic, in his opening chapter, took us through the whole structure of the system within which we're working. And I don't know whether he put it quite in this way, but he's asking us to see how the question has to be addressed and the context in which it is being addressed. And that raises issues as to whether what we're really dealing with here is something which is racist or whether it is simply the inevitable product of a religious system.
Well, he relies on the exception in Section 50 of the 2006 Act, but that exception covers only discrimination on grounds of religion or belief. And it cannot be, it's not entirely clear to me how far the submissions both of Lord Panic and of Mr. Linden on this point go, whether they are actually suggesting that the scope of the Race Relations Act was somehow, by implication, limited or altered by the 2006 Act. In my submission, that's an impossible proposition. The result of this case cannot be different if it was brought in 2005 or if it is before this court now. So, in a sense, the question whether this is or is not religious discrimination is irrelevant. The question is whether it is also, or alternatively, race discrimination. And if it is, it will not be saved by the exception in the 2006 Act. Of course, what Parliament could have done when it enacted the 2006 Act was to use that opportunity to insert a new exception into the Race Relations Act, and a new exception to Section 17 of the Race Relations Act. But Parliament chose not to do that. And so what one therefore has is a policy choice by Parliament that it is acceptable for a faith school to discriminate on grounds of faith or religion, but not acceptable for it to discriminate on racial grounds.
But Ms. Rose, I mean, you say it's not racist to say that M is not a member of the Jewish religion, but it is racist to say that because he's not a member of the Jewish religion, we won't admit him to our Jewish school.
Yes, my Lord, because people are entitled to say what they like in this country, and the Race Relations Act only outlaws discrimination in certain particular circumstances.
Can they keep him out of a synagogue on the count because he's not a member of the Jewish religion?
Yes, because a synagogue is a charity.
I see. So they might have to admit him to a school, although he can never go to synagogue.
Well, of course, he does go to synagogue. He goes to the synagogue where
I know he does,
worships,
but I mean, we're deciding the case, a matter of principle. And
absolutely.
On your argument, I mean, you could very well have a child who you have to admit to school, but who you don't have to admit to a synagogue.
Absolutely, my Lord. But there's no surprise in that. That is the case in relation to all faith schools that are undersubscribed. If JFS were to become less popular and have spare places, it would be under a legal obligation to offer those places to children with no Jewish connection at all.
Oh, of course.
So there's no surprise that people would have to be admitted to school who wouldn't be admitted to synagogue. The question is, when you have somebody who is in fact an actively practicing Jew, whether you can exclude them on this ground.
No, but I mean, in an oversubscribed school, you have to admit a child who couldn't go to synagogue, and possibly on that account, well, indeed, almost certainly on that account, refuse a child who could go to synagogue.
But, my Lord, this school, of course, is admitting children who may be baptised Catholics, actively practising Catholics.
I mean, the oddity, one oddity of the case, or an irony of the case, I mean, if you're right, actually, there will be less diversity in the school. I mean, there will be more who are, so to speak, practising than there are at the moment.
Well, my Lord, that depends on what entry criteria the school chooses to use, and also depends on what you mean by diversity. Of course, at the moment, the school is less ethnically diverse because it has fewer children of those who have converted to Judaism who are likely to come from a wider range of racial groups. In terms of the diversity of religion and practice, of course, if the school adopts a practice criterion, most or all of the children in the school will be practicing Jews. But that is perhaps the result one would naturally expect from what is, after all, intended to be a faith school serving a faith community.
Mr. Rose, you said a moment ago that a synagogue is a charity.
Yes.
I think were you hinting at Section 34 of the Race
Yes.
Relations Act?
Yes.
I think it's right to point out that section is directed to provisions which are contained in charitable instruments.
That's true.
So one's got to be a bit careful. It doesn't give a blanket permission to all charities.
There is also Section 26 dealing with associations.
Yes.
Yes, 25 and 26 dealing with associations of more than 25 people.
But, I mean, it doesn't seem to me that any of these exceptions and so on assist in the question as to whether or not the test which is being applied is racist. I mean, if the chief rabbi's test, when applied to school admissions, means it's racist within the definition of the Act, the Race Relations Act, if he applies exactly the same test to deciding whether to admit somebody to a synagogue or so on, it's not legally irrelevant. It's not legally irrelevant because it's not covered by the Race Relations Act, but it still must be racist.
Well,
it must be. I mean, I don't understand how you can marry up both sides of your argument.
my lord, it's race-based, but it's not unlawful.
No, it's not. I'm
But
not
there is
saying it's
nothing
unlawful.
wrong. The point I'm making is there is nothing morally objectionable about members of a single ethnic group wishing to gather and associate together. Take, for example, a Polish club.
Yeah,
You have a Polish club which is open to people who have Polish antecedents. Now, you can say it's racist for the Poles to have their own club, but that would be an absurd way of putting it. The Poles gain great pleasure from each other's company, and they eat their traditional foods and drink vodka, and they're entitled to do that. And it's not racist for them to want to be with other Poles. But if they were to set up a Polish school and say only Polish children can be admitted to that school, that would be a different matter.
Why is it not? I mean, why is it not racist to say only I can't. I mean, why is it?
It's racist.
It's the same way.
Yes,
I mean, if I say I'm only going to allow Poles to come into my club, I'm only going to allow Poles to go into my school. I mean, they're both the same thing. Of course,
Absolutely.
one is covered by the Act and one isn't.
Exactly. That's right.
Well,
but racist is a pejorative term, and my point is it's not pejoratively or unlawfully racist for people to wish to associate with others.
You're distinguishing racist and race-based.
Yes.
And really you're saying it's racist if you're offending against the Race Relations
Yes,
Act.
yes.
Now, can I just put this to you? The criteria of an ethnic group must be criteria one can identify objectively, not subjectively. Isn't that right?
Well,
if the chief rabbi said that to be in the Jewish faith, you've got to have played rugby football.
Yes.
You couldn't say that
wouldn't
was a criteria.
That would not be racist. No, I agree. Totally agree. Yes, totally.
Well, it wouldn't be. I mean, just to take... If a school decided that it would only admit the children of parents whose income was less than £15,000 a year,
yes,
that would be a perfectly legitimate criterion.
Well, subject to other provisions in the admissions code about social.
Yes, it wouldn't be. It wouldn't be
racist.
racial.
No.
It wouldn't be ethnic.
No.
Oh.
My lord, I'm slightly anxious about time because I haven't made any progress at all in the last 20 minutes, and Lord Panic is getting very twitchy. So, without turning it up, can I just draw to the court's attention that the test that was identified in Mandler is very similar to a test that was more recently adopted by the European Court of Human Rights for identifying an ethnic group in the case of Timishev and Russia. And that case is in the new bundle of authorities that we handed up yesterday at tab 5. Without wishing to go to it, if the court looks at paragraphs 5, 56 and 58 of that decision, you will see a test of ethnicity, which is strikingly similar to that used by the House of Lords in Mandler. Now, can I now turn to the factual question? What is the nature of the inquiry, which is actually conducted by the Office of the Chief Rabbi for determining somebody's religious status? Because, with respect to Lord Panic, this is a matter that has been somewhat fudged by the appellant, who suggested that it was to do with being a descendant of an Orthodox Jew. And that, of course, raises the category confusion which Mr. Wolfson pointed out as to what do you mean by an Orthodox Jew. You don't mean, in this context, someone who practices orthodoxy. You mean somebody who has recognised status. And we need to look and see exactly what that means. So if we go first to the application form for Jewish status, this is part 2 of the appendix, page 424. If the court looks very briefly at 423, you'll see the covering letter, which was sent out with this form. This is the form which the Office of the Chief Rabbi sent out to schools for schools' use in their admissions procedures. And you can see at 424, first of all, there are the details of the parents, the mother, name, and so on. And then, please select one of the following options. A, I confirm that the child's biological mother is Jewish by birth. B, I confirm that the child's biological mother has converted to Judaism. C, I confirm that the child is adopted. Please refer to box C. And we then look at box A, and they tell you what supporting documents they want, in particular, birth certificate and the Orthodox marriage certificate. Then box B, they want proof of conversion. And box C, they need separate evidence of the adopted child's status. And then at 425 are the notes for guidance. Jewish status is not dependent on synagogue affiliation per se. The Jewish status will not be confirmed if the child or any of his or her maternal antecedents converted to Judaism under non-Orthodox auspices. If the child's parents were not married under Orthodox auspices, further investigation will be necessary before confirmation of Jewish status is issued. This usually entails obtaining additional documentary evidence down the maternal line. And the nature of the inquiry is expanded on in the witness statements of Mr. Fry and Diane Gelly. So if we go first to Mr. Fry's witness statement, this is in the same volume, at page 544. And reading this witness statement and that of Diane Gelly, I would invite you to have in mind not only the point that I'm now on, which is what is the actual nature of the inquiry, but also whether there is really any distinction from the point of view of these witnesses between Jewish religious status and Jewishness in any other sense at all. Because in my submission, it's very clear that all of these peoples, either you're Jewish or you're not Jewish. And Lord Panik's suggestion that the Chief Rabbi might regard M as Jewish in some ethnic sense, although not religiously Jewish, in my submission is contrary to the evidence. But if we look at these paragraphs, first of all, paragraph 4, in the United Synagogue, as in any other body under Orthodox Jewish law, the criterion of Jewish identity, and I invite the court to see that, Jewish identity, is that the person concerned is either A, born to a Jewish mother, or B, has undergone a valid Orthodox conversion to Judaism. These rules are universally accepted within Jewish orthodoxy and have been for millennia. The usual means of showing Jewish status is by producing evidence that the person's parents or maternal grandparents were married in an Orthodox Jewish wedding ceremony. This provides good evidence of Jewish status because permission to marry in an Orthodox ceremony is only granted if the couple are Jewish. Now, this is important because what's relevant and significant from the perspective of Mr. Fry, and indeed all the halakhic authorities, is not whether any of the maternal antecedents were practicing Orthodox Judaism, but whether they had Jewish identity or Jewish status. And the relevance of their marriage in an Orthodox ceremony is not that it demonstrates that they were loyal adherents to the faith, but that the fact that they had permission to do that shows that the rabbi at the time ticked the box that said that the woman was of Jewish antecedents. So it's simply evidential. Sometimes one may have to go back several generations in order to find antecedents through the maternal line who have married in an Orthodox.
Of what?
Descent from the original tribe, my lord, and we see this in a moment. When such evidence is unavailable, Other documentary evidence may be accepted, and in the absence of documentary evidence, oral evidence may also be accepted. And again, one asks, oral evidence of what? And in my submission, it's simply oral evidence of Jewish descent from time immemorial that is at issue.
And that's what Jewish by birth means on page 424.
Yes, my lord.
I noticed that you used the word tribe. I noticed that on the application for confirmation of Jewish status, children were invited to become a tribe member.
Yes, well, tribe is a youth group run by the United Synagogue. Its name perhaps speaks for itself. Paragraph 9, attendance at the services of a synagogue has no bearing on a person's Jewish status as a matter of Jewish religious law. Being Jewish is a matter of religious status under Jewish religious law. And then he then attaches to his witness statement a note giving certain further information. And if the court turns
is every Manda Jew a Jewish person by the same test?
Well, my lord, in my submission, that's the wrong question.
Well, maybe it is, but what's the answer?
Can I explain first why it's the wrong question?
Well, as long as you promise to answer based on the hypothesis that you're wrong. Oh. Wrong question.
The reason that's the wrong question is that it suggests that there is somebody who can be objectively identified as a Mandla Jew. And, of course, the question whether somebody is or is not a Mandla Jew is a subjective question, depending partly on their own self-perception and, critically in the discrimination context, on the perception of the person who is treating them less favourably. So if the person regards the individual as a Mandla Jew and treats them less favourably for that purpose, whether they are or not a Mandla Jew is A, irrelevant, and B, maybe impossible to determine. Because how can you say, if a person who has a remote Jewish antecedent but has no connection with the Jewish community, are they or are they not a Mandla Jew? Depends on the perception of the discriminator. If that person is excluded from a shop that says no Jews or dogs because the shop owner thinks that they're Jewish, they're a Mandla Jew. They're protected, whatever they think.
But surely everybody who's under consideration here, I mean, everybody's a Mandla Jew. There's no question about that.
Whether they're Jewish or not, or as I said, Armenian.
Absolutely. But I mean, what the chief rabbi is doing is choosing between Mandla Jews those who are members of the Jewish religion.
No, my lord, I'm sorry, we're at cross purposes. My point is a different one, which is that you can't identify a group of Mandla Jews and then say what the chief rabbi is doing is selecting some of the Mandla Jews. That is Lord Panik's approach, and in my submission that is incorrect. The reason it's incorrect is because it leaves out of the equation the perception of the chief rabbi. And the whole point is that the chief rabbi is saying simply, you are not a Jew. And the reason you are not a Jew is that your mother was not a Jew. That's it. End of story. And therefore, if you ask what is the ground for the treatment, it is the ethnic origins. Now, whether that person might be perceived by other people as a Jew has no bearing on the case. But can I just deal with this evidence? It's at page 548. Paragraph 3.2.1. Jewish law defines as a Jew as anyone, male or female, who is either the child of a Jewish mother, using a principle... Sorry, page 548. Anyone who is either the child of a Jewish mother using a principle known as matrilineal descent, this principle is derived from Deuteronomy, or a person who formally converts to Judaism under the auspices of a halakhically constituted Beth Din. And then paragraph 3.3, Judaism believes that the covenant at Sinai, where the Jewish people accepted the Torah, was made not only with the generation alive at that time, but also with future generations, and indeed with future converts to Judaism. This is derived from Deuteronomy. The underlying idea is that the divine revelation of the Torah to the Jewish people at Mount Sinai took place in the presence of all the souls that had corporeal existence at the time and those who were yet to be born. The covenant of Sinai is therefore considered religiously to be automatically binding on all Jews, even though they individually and personally were not present at its inception. These principles underpin the conviction of Orthodox Jews that a person born of a Jewish mother is automatically and inalienably Jewish. And I would invite the court to compare that paragraph with the paragraphs that we were just looking at in Mandla, citing King Ansel, and ask the question, is this about descent from a presumed historical common stock? And the answer is clearly yes. It's nothing to do with religious observance. It is the descendants of the children of Israel who were gathered at Mount Sinai. That is the concept, that is the idea.
When we read Jewish law in 3.2.1, we actually have to understand Jewish law as interpreted by Orthodox Jews.
Well, in fact, all branches would have a variant of that. The liberals would say father or mother, and of course the nature of the Beth Din that would be accepted would be different, but that is...
Yes, but they would have a wider definition.
In that sense, but the basic principles would be the same. The basic principles would be the same.
So that last sentence of 3.3, the word orthodox is redundant, is it? I mean, would that be right? It's the conviction of all Jews.
It's all conviction of all Jews that a person born of a Jewish mother is automatically an Jew. Yes. Absolutely, yes. Then, very briefly, if I can just identify without reading it out, paragraph 4.3, where we see a description of conversion. And the court can see from that how onerous a process conversion is, that there has to be a total and unconditional commitment to accept the tenets of orthodoxy and practice its detailed laws, and that then a person must have studied Orthodox Judaism for an extended period with a recognised teacher and so forth. And I'm going to return to this point, but one can see the clear distinction between those who inherit their Jewish status on the basis that they are descendant of the people and those who seek to convert, to whom a wholly different test, entirely religious test, based on very, very strict adherence to orthodoxy is applied.
But here there's a different test for between the different orthodoxies.
Yes, there is. But this is the test that's material for this case.
He is quite interested to spend a substantial period of time living in a Jewish environment. Yes, meaning an Orthodox Jewish environment. And of course, that makes conversion, in practical terms, an impossibility for a child, Orthodox conversion, in practical terms, an impossibility for a child who lives in a Reform or Masorti environment. It would simply be impossible for the child to comply with that condition at all. Diane Gelly, his statement starts at page 590, and the relevant part is at paragraphs 15 to 17. And he says at 15 and 16 very similar things to those that were said by Mr. Fry. Then at paragraph 17 is an interesting point. He says it's not only converts, this is page 594, he says it's not only converts whose Jewish status is subject to checking and verification. The London Beth Din regularly deals with complex issues of Jewish status. For example, in cases involving Holocaust survivors and their descendants, there are commonly no written records available. In such cases, the Beth Din will hear oral or anecdotal evidence from the surviving relatives and contemporaries of those involved. In other cases, detailed genealogical research is needed to establish Jewish status. And what one sees constantly is that the nature of the inquiry is always, was this person a member of the Jewish people? There's no question, there's no consideration of their orthodoxy of practice. It is all about descent from a presumed common stock. And in relation to conversion and becoming a member of the ethnic group by conversion...
But what are the tests apart from marriage? I mean, or the indicia?
Well, I'm not qualified to answer that question. It would have to be answered by an expert witness on behalf of the Beth Din. But I would assume that what they're looking at is evidence of somebody's participation in the Jewish community and the fact that they were accepted by other members of the Jewish community as being Jewish, which would be an indication that they were in fact Jewish. Remembering, of course, that this would have been in an environment where being Jewish was hardly a prized characteristic. For much of the last 2 millennia, being Jewish has been a passport to persecution and abuse. And therefore, if you had evidence that somebody was a recognised member of the Jewish community, that would be pretty strong evidence that they were, in fact, what they purported to be.
And that evidence could be participation of an entirely non-religious nature, could it?
Yes, but it's unlikely to be, because this is an ethnic group which has always been bound together by its religious customs. So it's very likely that you would be looking at a combination of cultural and religious factors. And that, of course, takes you straight back to Mandela, where the importance of belief systems and religious belief in particular in defining the ethnic group is stressed. I just want to make a point about people joining the ethnic group by conversion. And in my submission, this is something that is, in fact, well recognised and understood by the Chief Rabbi himself. There is a statement from the Chief Rabbi at page 607 relating to conversion. And at page 608, he's basically seeking to explain here why such strict and exacting conversion standards are applied by the Orthodox Beth Din. And at page 608, the second paragraph from the bottom, he says, converting to Judaism is a serious undertaking because Judaism is not a mere creed. It involves a distinctive, detailed way of life. When people ask me why conversion to Judaism takes so long, I ask them to consider other cases of changed identity. And the court will recall that identity, again, is the word that was used by Mr. Fry, Jewish identity. How long does it take for a Briton to become an Italian? Ironic that he refers to Italian. Not just legally, but linguistically, culturally, behaviourally. It takes time. And then he says the analogy is imperfect, but it helps to explain the most puzzling aspect of conversion today, the different standards. And in my submission, Lord Panic would like to draw to your attention the rest of the paragraph, so I invite the court to read it. And he's making the point there that it's easier if you live in Israel because many aspects of Jewish identity are already reinforced by the surrounding culture. And in my submission, these points entirely support our submission that for the Chief Rabbi there is only one question, not two questions. Chief Rabbi doesn't say, does this person have Jewish religious status? But even if he doesn't, do I recognise him as an ethnic Jew or a Mandla Jew? That's not a question that's of any interest to the Chief Rabbi. Chief Rabbi says, is this somebody that I recognise as having Jewish identity? Either Jewish identity because descended from Jewish mothers going back to Sinai by implication, or having undertaken the fundamental change of identity, which is the Chief Rabbi's perception of the process of conversion, which we submit is plainly indicated here as a change of ethnic identity, linguistically, culturally, as well as religiously, a whole new identity. And we submit that the attempt by the appellants to mount a distinction between religious status and ethnic origins on the fact of this case is wholly inconsistent with the evidence. I also draw to the court's attention the fact that there is no evidence at all from the United Synagogue or from the school that they ever distinguished between ethnic Jews and those whom they regarded as halachic Jews. Lord Panic wishes your attention to be drawn to the first two paragraphs on 608. And I assume that he's making the point that conversion is irreducibly religious, but I invite you to read those paragraphs. So I was making the point...
So far as the test of descent is concerned, as
yes.
opposed to conversion,
yes.
Is the test the same in each of these denominations, or is it different?
Each denomination will be asking the same question. Are you descended from a
Will they
Jewish
be
mother?
applying the same criteria?
They will apply the same criteria. They may get different answers because they would accept different conversions in the maternal line.
Because if you're converted,
By
if your
reform.
mother or grandmother was converted,
By a reform
then
yes.
Then you get through the gate
Yes.
of descent.
Yes. But they're all essentially asking the same question.
But the process of conversion may differ.
Yes, the process of conversion is very different, yes. I'm just raising the point that, in fact, on the evidence, there was no distinction drawn by the school between ethnic Jews, or Mandla Jews, and those of Jewish religious status.
For what purpose? You
Sorry?
say no distinction was drawn.
For any purpose at all. Now, this is quite an important point. There is a procedure under Section 65 of the Race Relations Act, which entitles a complainant in a race discrimination case to ask questions of the discriminator, and the answers are admissible in evidence. And we asked questions using that procedure. So can I just draw your attention to part 3 of the appendix, page 1183.
1183.
1183. This is our statutory questionnaire. And at 1184, question 2. In respect of each year of the school's Year 7 intake for the last 3 years, please also state at the time of application and or decision or admission was taken how many children were halakhically Jewish and how many were not, and B, how many of those children were halakhically Jewish by matrilineal descent, how many because the children themselves had converted, and then at E, we asked the question how many children were Jewish on account of their race or ethnic origins and how many were not. So we were there asking them a question which distinguished between those whom the school recognised as halakhic Jews, as having Jewish religious status, and those whom the school recognised as having Jewish ethnic origins. And we received the following reply. It's at page 1198. The little e, which is the crucial question, is answered at 1199. How many children were Jewish on account of their race or ethnic origins and how many were not? Those children confirmed as halakhically Jewish were treated as Jewish by the school, and those not so confirmed were treated as not Jewish. Now, in my submission, that is the clearest possible evidence of the perception of the discriminator in this case. That we were specifically identifying to the school the question of whether they drew a distinction between halakhic Jews and ethnic Jews, and they were telling us they did not. We then responded to this positively by pleading a case based upon it. This is at part 1 of the appendix in the core volume. Page 271 of part 1 of the appendix. Paragraph 4, this is our response to their notice of acknowledgement of service in the light of their responses to the questionnaire. Paragraph 4 on page 271, we specifically relied upon the exchange that I've just shown to the court and said this is an admission that the defendant treats those confirmed to be halakhically Jewish children as children who are Jewish on account of their race or ethnic origins. In other words, the defendants now belatedly but rightly accept that halakhical Jewish status is synonymous with membership of a racial group. That plea was never denied at any stage by the defendant, and no evidence was at any stage submitted by the school or by the United Synagogue to say to the contrary. And I remind you again that, of course, Section 65, the responses to the questionnaire are admissible in evidence. So we had specifically drawn this point to their attention, and they never sought to dispute it. Indeed, it was not until the proceedings in the Court of Appeal that Lord Panic, acting at that time not for the school, but for the United Synagogue, for the first time raised the argument that the chief rabbi regarded these children as ethnically Jewish, although not halakhically Jewish. That point was not run at all at first instance. We submit it's plainly contrary to the evidence of Diane Gelly and Mr. Fry and their response to the questionnaire, and that there is no evidence to support it.
I'm not sure I've really quite followed the point. I'm sorry, Rose. you're finding the answer to E.
Yes.
Is that right?
Yes.
And you say that the answer they gave is an admission as to what?
Well, we asked the question.
I know what you asked.
You have to look at all the sub-paragraphs of our question. We asked them how many of the children you admitted or who applied to you were halakhically Jewish and how many were not. And they answered that and gave us the figures. Then we asked them the question, how many were ethnically Jewish and how many were not? And they said simply, all those who were halakhically Jewish were treated as Jewish and all those who were not were treated as not Jewish. In other words, they were explicitly stating that they drew no distinction between those who were halakhically Jewish and those who were ethnically Jewish. They drew no distinction.
For what purpose?
For the purpose of admissions.
Does it actually ask that question in relation to admission?
Well, that's the whole context, of course, of the questionnaire. I'm sorry, it's very difficult. I'm trying to deal with the time pressure. But if we go back to the questionnaire...
How were 13 or 14 or whatever admitted by accident?
No, they were not admitted. They were rejected.
Oh, I see.
They were candidates.
Oh, they were candidates.
Yes.
The question did relate specifically to admission.
Indeed it did, yes.
It says at the time of application and or
Yes,
decision on
yes,
admission.
yes. So we were asking them, when people applied to you, how many were ethnically Jewish, how many were halakhically Jewish? And they said we treated them in the same way.
So it's directly on the oversubscription point.
Exactly, and they were saying we drew no distinction between halakhic Jews and ethnic Jews.
Yeah.
Well,
treated them as meaning the same thing.
Treated them as meaning the same thing.
Nobody who was rejected was Jewish.
Exactly, for any purpose. That end of story, exactly. And we say it's not until Lord Panic is instructed in the Court of Appeal for the United Synagogue that this distinction even becomes part of the case.
I'm totally, I'm bemused. I mean, the answer simply says the only Jews we're interested in are those who are halakhically Jewish. We're not interested in the rest. We don't care if they are or aren't treated as Mandler Jews by anybody else. That's not the question we're concerned with. We're only concerned with those who are halakhically Jewish. Well, I don't understand what that gives away.
But the point is that they don't treat them as Jewish. For any purpose.
They weren't interested in that question.
Yes.
They were only interested in the question whether they were halakhically Jews.
But they are not drawing any distinction between halakhic Jews and ethnic Jews. And when we specifically put that point to them, we don't get a response from them saying, oh, no, this is completely wrong.
Well, that's because they're not interested in that. They're only interested in the question whether they're Orthodox Jews.
Well, they're only interested in whether the child is Jewish. And they don't draw any distinction. They're not sitting there going, oh, look, that's an ethnically Jewish child, but we can't take them because they're not halakhically Jewish. They're just asking, is this child Jewish or not?
And they were,
or are they not simply asking, is this child Orthodox Jewish?
No, Orthodox Jewish is not a meaningful category.
Halakhically Jewish. I'm sorry, I can't speak.
Halakhically Jewish.
they weren't being asked a question about their attitude. They were being asked an objective question.
Yes.
And if they had regarded the Mandler tests as having any relevance, then your point is they would have said,
Yes.
we accept them as Jewish.
Yes, Jewish ethnicity, but not good enough for our purposes. But instead they simply say, if they're not halakhically Jewish, then from our perspective, they're not Jewish. They could, of course, have answered that question saying, as they did in relation to some other questions, we didn't keep the data on that. They could have said, well, some of them may have been ethnically Jewish, but we didn't keep those figures. And they did say that in relation to some of our other questions. But they chose not to answer that question that way.
You read it with A, I suppose. The answer to E is to be read with A.
Yes. Yes, my lord. And also to be read with our subsequent pleading, which was never denied or responded to by evidence. That then brings me to an important hypothetical which was posed by the Court of Appeal and which was also raised by this court with Lord Panic, but to which in my submission he has no proper answer. And that is the situation of a Christian faith school which declines to accept children who are regarded as Jewish by the office of the chief rabbi. And the question is that school acting unlawfully or not? Because if that school is discriminating on religious grounds, and it's a faith school, then it has a defence under Section 50 of the 2006 Act.
Right, what are we postulating? An oversubscribed
Christian school, faith school
who
say, while we're oversubscribed, they say we have a sincere religious belief that the Jews were responsible for the killing of Jesus. And because of that, we will not admit to this school those who are recognised as Jewish by the office of the chief rabbi. The question is that discrimination on religious grounds or on racial grounds? If it's only on religious grounds, as Lord Panic would have to say, then it is lawful, because it falls within Section 50 of the 2006 Act. In my submission, it is not lawful, because those children may be baptised Christians themselves, may be atheists, may or may not be practising Jews. They're being excluded from that school because of who their mother is, because their mother was Jewish. And to exclude those children from that school because they are descended from Jews in the maternal line is race discrimination, regardless of the fact that there's a sincere religious motive.
But I mean, is it a tenet of any branch of Christianity that those who are regarded as Jews under the Jewish religious law, they're the people who are responsible for the killing of Christ and therefore must be barred?
Well, I would hope very much not, but...
well, if it was, I mean, it's a different question. If it isn't, I'm not trying to follow.
Well, the question is a hypothetical question, but the maintenance of Jewish quotas by schools, including Christian foundations, is not hypothetical. When I was a child growing up in North London, there were many schools, Christian foundations, which operated a quota and would only allow in 10% of Jewish children. And if they said, well, we do that for sincere religious reasons, perhaps they might have a less offensive reason. They might say, well, we wish to give priority to Christian children. This is a Christian school, we don't want to be swamped by Jewish children. But they have to have some means of defining who are the Jewish children that they're going to exclude or limit participating in the school. And they say, well, the easiest thing is we'll adopt the chief rabbi's definition because he knows who's a Jew and who's not. So anybody who's a Jew in accordance with the office of the chief rabbi, either you're subject to the quota system or you can't come to this school. Is that lawful? In my submission, that is plainly unlawful race discrimination because the beliefs of the child are not determinative. It is the child's descent from a Jewish mother which will result in the child being excluded from the school.
The introduction of the chief rabbi tends to muddy the waters, doesn't it? You've got to look at the criteria which is resulting in the child being excluded. And if those are, as it were, racial criteria, criteria which objectively form part of the ethnic group, and you exclude because of that, then that's racial discrimination. But if the chief rabbi were, as I said, saying that anybody who played rugby football is going to be considered a Jew.
No, it is the criteria.
This is because the chief rabbi thinks that rugby football players are Jews, I'm going to exclude rugby football players. Of course. That wouldn't be racial discrimination. That's correct.
But I'm assuming that the chief rabbi applies the criteria that he in fact applies. And my submission is that that criterion of matrilineal descent from a Jewish mother as a basis for excluding a child from a school is plainly race discrimination. And the fact that the person who operates that criterion does so for sincere religious motive has no bearing upon the fact that it is race discrimination. It might be religious discrimination as well, but that doesn't matter. It's race discrimination. And if that is so, then the contrary proposition must also be so. To exclude a child because he does not have a Jewish mother is just as discriminatory as to exclude a child because he does. And we submit that that is the inescapable dilemma in which Lord Panic finds himself on the facts of this case.
When you say that it might be religious discrimination as well, does that mean that you accept that the decision may have been taken on religious grounds?
My Lord, I don't comment on the decision in this case. I'm saying in the hypothetical instance, you might or might not seek to characterise it as religious discrimination, but the point I'm making is that that characterisation makes no difference for our purposes. The fact that the 2006 Act might also be in play has no bearing on the ambit of the Race Relations Act.
Well, quite so, but what about this case?
Well, my submission in relation to this case is that this is a case of race discrimination with religious motive.
And it's not a case of religious discrimination?
That is my submission.
I think it has to be, doesn't it?
Yes, well, it doesn't have to be, actually, no. I could win on the basis... Yes, it could. Yes, I can win on either. I can win on either basis. But, well, they're muttering that it's both. But my own perception of it is that it is race discrimination with a religious motive. But it doesn't. It makes no difference.
It is, as long as it's race discrimination.
It doesn't matter what else it might be.
It doesn't matter what else it might be.
It's probably sex discrimination as well. It probably is. But it doesn't make any difference to the outcome. Okay, but can I just show? I've already.
But the tribunal or court does have to decide which it is, always, doesn't it? I mean, to take a black woman who is refused employment, and the notes actually say she's very highly qualified, but she wouldn't fit in because everyone else is a white male. You do actually have to decide whether that is sex discrimination or race discrimination.
Well, it's probably both.
But can you can say it's both, can you?
Absolutely, absolutely.
And do you have to decide which is the more important one or not?
No, you would have... No, that's a classic case of double discrimination. Of course, you succeed under the Nagarajan test if race or sex has a significant influence on the outcome. So that's the extent. It's got to be a significant influence. So in this case, both race and sex are having a significant influence on the outcome. Both are in play. But I've dealt with the hypothetical. Can I now come on to the implications? I made the point yesterday about loopholes for evasion. And I made the point that the result of Lorpanic's analysis would be to cause serious loopholes in the protection that the 1976 Act intended to convey. And of course, the hypothetical example I've just given of the Christian school is a good example of that in play. Another example is what actually happened in this case in the decision of the adjudicator in relation to JFS's undersubscription criterion. Now, if we go to part 1 of the appendix in the core volume, at page 297, JFS, as well as having its oversubscription criteria, the principal one of which is the one that we've been looking at, also had some fallback provisions about the priorities it would exercise if it couldn't fill its places with halakhic Jews. Those were in practice not implemented because it was already oversubscribed, but nevertheless it had criteria. And we see the criteria at page 297. So this, as you can see, is where applications for admission from children who satisfy paragraph 1.1, that's the criterion at issue in this case, are less than the total number of places available. And the first priority is children who are in care. And then 1.2, children with one Jewish parent. 1.3, children with one or more Jewish grandparents, and 1.4, all other applicants. So, if they're not filled with halakhic Jews, their intention then is to give subsidiary priority to those children who have some Jewish blood, even though they're not recognised.
That's surely not a definition of undersubscription, that they're not filled with.
No, well...
Undersubscription means you've got more places than you've got people applying for them, doesn't it?
Yes, that's right.
Well, why do you need any criteria, or why are you allowed to have any criteria?
Well, that's a different question. But this is what they actually did. What they were actually doing here. They can't fill the school with halakhic Jews, and so they want them...
That's still maybe an oversubscription situation, isn't it?
Well, it may be, my lord, but it's called the undersubscription criteria. But I'm sorry, it's just that I'm very worried about the time, so if we can just stick to the essentials. The essential point is that they, in this criterion, are giving priority to a child with one Jewish parent, which of course must mean the father for this purpose, then a child with one or more Jewish grandparent, and then everybody else. Now, in my submission, that is possibly the clearest example of direct race discrimination you could ever seek to find in a school's subscription criteria. It has nothing to do with religion, because from the perspective of the chief rabbi, none of these children are Jewish. They have no Jewish religious status. And yet, those who have some Jewish blood get priority. But the adjudicator had accepted the submission that this was religious and not race discrimination. And the adjudicator therefore found that this criterion was not directly racially discriminatory, but only indirectly racially discriminatory. In fact, he found it was unlawful because he decided it was unjustified. But let us look at the reasoning at page 289. Sorry, 281, I beg your pardon. At paragraph 11, there is a summary of the undersubscription criteria we've just looked at. And then at paragraph 19, sorry, I beg your pardon, paragraph 15, he says, I accept there is no direct discrimination, as the criteria are still based on religious grounds, not racial grounds, albeit the religion of the father or the grandparents. And for that reason, rejects direct race discrimination, then goes on to find it is unjustified. Now, in my submission, this is a classic application of the fallacy in the approach of the appellant in this case, leading to the wrong analysis of what is clearly a directly discriminatory criterion as being only indirectly discriminatory, which could have given the school a justification defence. And actually, this is a form of discrimination to which there could be no lawful justification.
I mean, that may well be right. Assume it's right. How does that bear on the other issue, which is...
Because in my submission, there is no conceptual difference between the school giving priority on admissions to a child with a Jewish mother and the school giving priority on admissions to a child with a Jewish father.
Well, except one is hallowed by millennia of Jewish Orthodox belief and the other has absolutely no basis at all in Jewish.
Yes, absolutely, my lord. That is the difference. And that is why I make the submission that this is race discrimination with a religious motive. Because in the first instance, one can see that there is a powerful motive why the discriminator might want to act in that way. But in both instances, the ground for the difference in treatment is the racial or ethnic descent of the child. And this really points up the fallacy and the confusion between motive and ground. And what your lordship says to me, well, in the former case, there's a powerful history of millennia. That's precisely the difficulty with respect that courts find when dealing with direct discrimination cases where they think it's understandable that the discriminator acted in that way. Because of the absence of a statutory defence of justification, there is a great temptation for a court to define forms of discrimination which they see as understandable as not being direct discrimination, because then they can analyse them under the indirect discrimination ground as potentially justifiable. But in my submission, if you look here at the under- and oversubscription criteria, you cannot make any logical or conceptual distinction between the ground for the treatment. In both cases...
You say they're both discrimination?
Both. Yes, my lord. One has an entirely understandable religious motive behind it. The other doesn't even have that, which is why the adjudicator found it to be unjustified. But we submit that in neither case ought justification to have been in play.
And just to finish this, as I now understand what's meant by undersubscription,
yes,
your arguments on racial discrimination for the halakhical Jews applies equally to the undersubscribed situation, which has never existed, as it does to the oversubscribed.
Indeed.
They are giving number one preference,
yes,
and then there's further discrimination on a
yes,
different ground.
That's right, Lord. And that was exactly the argument we were mounting at that time to the adjudicator. Can I now turn to the hypotheticals that were advanced by Lord Panic, and which form really the core of his argument in his printed case and were developed by him orally. This is paragraph 43 of Lord Panic's case in the core volume. There isn't a single page number, it's the case for the first and second appellants. And I'm going to paragraph 43 on page 26. And this, in my submission, is really the heart of the school's reasoning, and when analysed, one can see what is wrong with it. So, paragraph 43, page 26. He says, in the present case, the refusal to offer a place at JFS to M was on the ground that he is not Jewish as a matter of religion. And of course, the court already has my submission that that is plainly wrong. Common ground in this case that he is Jewish as a matter of religion. He is a Masorti Jew. JFS applies the criteria stated by the chief rabbi, who is not concerned with whether a child is Jewish as a matter of race or ethnic origin, but is concerned with religious status. That's true in terms of the motivation of the chief rabbi, but doesn't answer the question of the ground of his decision. That the chief rabbi is concerned with the prospective pupil's religion, and there one sees the elision between what the pupil believes and what the chief rabbi believes the pupil's status to be. The term the pupil's religion is deeply ambiguous in that sense. Not with his ethnic origin is demonstrated by considering the treatment of two contrasting cases. And then we have the first of his hypotheticals, which is essentially the facts of this case. And towards the bottom of page 26, it said, there can be no doubt that the family are all of Jewish ethnic origins for the purposes of the 76 Act. If the mother were to be refused a job because she is Jewish as a matter of ethnic origins, she would be able to bring a race discrimination claim. And there we say the fallacy is that whether she's of Jewish ethnic origins is being treated as if it were an objective question that would or would not entitle her to claim under the Race Relations Act, when of course the reality is that her entitlement to claim under that act would depend on the perception of the person discriminating against her. If she wasn't Jewish at all and had never had any connection with Jews, but was refused a job because the person to whom she applied thought she was Jewish, she would have a claim under the Race Relations Act. So that is irrelevant. And the assertion by Lord Panic that there can be no doubt that the family are all of Jewish ethnic origins may express Lord Panic's view of the status of this family, but does not express the chief rabbi's view, because the chief rabbi's view, very simply, is the father is Jewish, the mother is not Jewish, and therefore the child is not Jewish. That's it. So that's what's wrong with the first hypothesis. And so the argument by Lord Panic on page 27 that there is a distinction between the son's ethnic origin for the purpose of the 76 Act, which is Jewish, and his religion as recognised by the chief rabbi, which is not Jewish, we say entirely misses the point and misunderstands the statutory scheme.
Not just the chief rabbi, but the whole community.
The whole community, yes. Don't recognise the child as Jewish at all,
yes,
is the truth. And it's their perception that matters for this purpose. Then his second hypothetical is at sub-paragraph 2. The person who's not of Jewish ethnic origins, but he says who is Jewish as a matter of religious law. And he posits the woman who converts...
I'm really puzzled by this. Supposing that the person who is in this first category was subject to abuse by somebody outside in the street, and this was seen by the chief rabbi, would he say that he was being persecuted as a Jew?
Well,
as an ethnic Jew?
It would depend on the motivation of the person doing the abusing.
Assume that the person doing it. What would the chief rabbi think?
Well, the point is this: if the person sees the child, if the person sees child M wearing a kippah and abuses him as a Jew, the chief rabbi would rightly say this child has been subjected to racial abuse. But that has no bearing on whether the chief rabbi regards the child as a Jew or not. What the chief rabbi is responding to is the anti-Semitic abuse of the child. Let's say that the child was Armenian and had no connection with the Jewish community, but looked Jewish, and the anti-Semite abused him as a Jew, the chief rabbi would still say that child has been subjected to anti-Semitic abuse. Whether the child is a Jew or not is irrelevant. That's a point that was made by Lord Justice Lawrence Collins in the English case that we looked at yesterday.
I understand that you...
Yes.
I understand the point of that, but I just want to know whether he, in that context, would say that that person was Jewish.
Well, there is no evidence on that question at all.
But you're saying he wouldn't. There's no
Well, he doesn't regard the child as Jewish, no.
But of Jewish ethnic origins?
No, my lord, he doesn't regard the child as Jewish ethnic origins because he regards the child's mother as not being Jewish at all.
I understand he doesn't for religious purposes.
Yes.
He doesn't think
for any
the child
purpose.
is...
For any purpose.
That seems to beg the question.
Yes.
I mean, the child could be living in this community and so on, and it's kind of highly orthodox community and all that sort of thing. You could see all that. But he wouldn't think he was Jewish because of the religious test.
Yes, that's
Does
right.
it follow that he wouldn't think he was ethnically Jewish for the purposes of one applying that sort of test?
It just simply isn't a distinction that the chief rabbi draws. The chief rabbi...
Not when he's in business, not when he's on his duty of deciding who is Jewish for religious purposes.
And of course, the discriminator here is the school, and your lordship has the benefit of the material we just looked at, the questionnaire responses, and the evidence, where it's made very clear by the school that for admissions purposes, you're either Jewish or you're not. That's it. And that is the only thing that matters for the purposes of this case. The second hypothetical example that Lord Panic gives is the woman who converts to Judaism by orthodox means, then loses all interest in Judaism, has a child, but they have no connection with Judaism, and indeed they practice another faith, and the chief rabbi regards the child as Jewish. But again, what Lord Panic says is, at 28, it could not sensibly be said that the ethnic origin of the woman or her child is Jewish for the purposes of the 76 Act. But that, again, begs the question. It depends who's doing the discriminating. If a person regards the child as Jewish because they regard their mother as Jewish and treats them less favourably for that reason, excludes them from the Christian school, for example, then they are protected by the Race Relations Act, because the reason why the child has been excluded is on the grounds of the child's ethnic origins. The question whether objectively the child or his mother are ethnically Jewish is simply irrelevant. It has to do with the ground for the decision.
That's because there's of a mistake of fact, not some mistaken view of
well, my lord, it's more subtle than that. There isn't a fact. There is no objective standard by which you can say this person is or is not of Jewish ethnic origins. It is a subjective question. It depends who's looking. And there are people who will self-identify as Jewish by religion, but not of Jewish ethnic origins. Many people who will identify as of mixed ethnic origins, and indeed M, in this case, might very well identify as of part Jewish, part Italian ethnic origins. People's identities are fluid and complex, and you cannot categorise one person as in a Mandela group and another person as outside a Mandela group. The question is always a different question, which is, what is the ground on which the discriminator acts in treating the person less favourably? Is it his perception that the person is of a particular ethnic origin? Is it the ethnic origin as perceived by the discriminator? And indeed, the implication of Lord Panic's hypotheticals there is that if the second child were refused a job because the employer didn't like Jews, he would have no claim under the Race Relations Act. That is manifestly incorrect. And we see the same error repeated at paragraph 44 of his printed case, where he argues that many children who have ethnic origins, Jewish ethnic origins, do qualify for admission to JFS, many with Jewish ethnic origins don't qualify, and some children who lack Jewish ethnic origins also qualify. And again, in my submission, these distinctions are meaningless because he seeks to rely on an objective test of Jewish ethnic origins and not on the subjective perception of the discriminator. Now that brings me to the question of the relevance of conversion. And much of this has been prefigured in my earlier submissions. If we are talking about the conversion of the mother, the first important point to note is that the mother must have converted to Judaism before the birth of the child. So this is something that at the date of the child's admission to the school, he can do absolutely nothing about. If there was a defect in her conversion before he was born, that's too bad, he's out. And we see that operating particularly in the case of the Lightmans. In the case of the Lightmans, fully orthodox conversion, fully orthodox family. By the way, it was said by, I believe, a number of the other side that no distinction was drawn in Jewish law between a convert and somebody who was born Jewish, that they had full rights. The case of the Lightmans shows us that that is plainly not correct, because the error that the Lightmans made was to get married. And under Jewish law, a Cohen, a priest, a descendant of the priestly caste, is not permitted to marry a convert. So converts don't, in fact, have equal rights. I'm happy to say we don't need to grapple with that question. But the crucial point is that those events take place many years before the child is born, but the child is penalised because the child cannot demonstrate that they have the right sort of mother and therefore excluded from the school. And we submit plainly then still on the grounds of ethnic origins, because you're still asking the same Mandler test based, in that case, on whether the mother who converted before the child was born had been recognised as Jewish. The second way in which conversion is potentially relevant is the second limb of the oversubscription criteria, which permits the child to enter the school if the child converts or is in the process of conversion. And we submit that the analysis of the Human Rights Commission and of the Court of Appeal on this is plainly correct. That conversion, common ground, is a highly onerous and rigorous process which requires total commitment to the principles of orthodoxy, years of study and immersion in an orthodox Jewish environment. And therefore, plainly, if you ask the question, is it less favourable to be required to enter the school through that route, or simply through the accident of birth, where you need to do nothing whatsoever in terms of religious practice, it's plainly less favourable. And the analogy that was drawn by the Court of Appeal, we say correctly, is if you had a club that said all men are admitted and women who are graduates are admitted. The fact that you admit some women on a more onerous condition doesn't stop it being sex discrimination. I also draw to your attention, without having to turn it up, is that the adjudicator, in fact...
Sorry, is that indirect discrimination?
No, that's direct, my lord. That's direct. Because you're applying a more onerous... You're not applying the same entry condition equally to both groups. All men may join the Garrick Club.
All right, yeah.
Women, of course, may not at all, but imagine a magical world in which they were allowed in, but only if they were graduates. That would be direct discrimination, because a woman and a man in comparable situation without a degree, the woman would not be allowed in, but the man would. And similarly here, if you have two children, neither of whom practice Orthodox Judaism, both are Masorti Jews, the one whose mother was born Jewish gets admission to the school, the other cannot, and cannot through the conversion route either. Before I leave that point very briefly, the adjudicator doubted, in any event, that the conversion route was a realistic route of entry to the school. He didn't actually overturn it because he said, well, it didn't actually seem to have been in play. No child has ever entered the school under this route, by the way. But if you turn to the appendix, part 1, page 284, there is discussion of the unreality of that as an entry route. Page 284 of part 1 of the appendix. Now, can I now turn to the implications of international human rights law for this analysis? Because we submit that the correctness of our analysis that the treatment of M as direct race discrimination is strongly supported by consideration of international human rights instruments. We submit that these instruments demonstrate first that very high priority is given to the protection of children against race discrimination in access to education, and that is a right which must be broadly and purposively construed. That's the first principle. We secondly submit that they demonstrate that race discrimination ought to be construed to include dissent, and certainly to include dissent from members of an ethnic group. And thirdly, we submit that they show that the right of access to a faith school is intended to secure the right of the child to education and the right of the parents to access for education for their child in accordance with the parents' religious beliefs and convictions. It is not intended to secure the right of a religious movement or body to secure preferential access for the education of children whose families do not share its beliefs. And that is the crucial point about this condition, that preferential access is given to children who have no interest in Judaism at all, do not share the beliefs of the chief rabbi, but they have preferential access because of how they are regarded by him. And the first relevant instrument is the Convention for the Elimination of Race Discrimination. That is volume 13 of the authorities' bundles.
Does that come down to this? It's intended to protect the pupils and their parents, yes, not those who run the school?
Yes, my Lord. Exactly. Schools are for the benefit of pupils, not external foundation bodies. That is the submission. Now, this is obviously going to be highly relevant when we come on to the question of justification of indirect discrimination also. But I could perhaps take this fairly lightly, given the shortage of time. Lord Panic referred to the point that dissent is specified at Article 1, but not at Article 5. But if we just look at it very quickly, what you can see, it's tab 88. That Article 1 defines racial discrimination. So that is a definition of racial discrimination, and it includes dissent. And Article 5 then says, states parties undertake to prohibit and to eliminate racial discrimination in all its forms. That must be a reference back to the definition of racial discrimination in Article 1, and to guarantee the right of everyone without distinction on the enumerated grounds to the enjoyment of the following rights. And we submit it can't sensibly be suggested that dissent was excluded from the ambit of Article 5, given the definition in Article 1. What one can infer is that those drafting this convention considered that dissent was self-evidently part of a race-based test, and therefore was included within the broader characteristics which are set out in Article 5. Now, Lord Panic relied on the decision, the Denmark case, dealing with Muslims, and that is at volume A1, at tab 5. But all that case says is that Muslims are not an ethnic group, and that therefore the abuse of Muslims is purely religious abuse and is not racial abuse. And this is a problem that legislatures have grappled with, particularly in recent years, in which Islamophobia has become more and more of a problem. Because Muslims, unlike Jews, are not a homogeneous group defined by their perceived descent from a common stock and by the various cultural and historical and linguistic factors that unite the Jewish people. Muslims are simply adherents to the religion of Islam from all over the world, very, very widely different cultures and ethnic and racial groups. And that is simply all that is being said in this decision. Lord Panic relied on paragraph 6.2, and in particular, he relied on the committee saying that the committee notes that the Muslims currently living in the state party of heterogeneous origin. They originate from at least 15 different countries, are of diverse national and ethnic origins, and consist of non-citizens and Danish citizens, including Danish converts. And he said the same applies here. Well, of course, that's absolutely wrong, because all of those who are admitted to this school are of Jewish ethnic origins in the maternal line, all of them. all of them. They're all descended from Jewish mothers. Either their mothers will have converted or they will have been born Jewish. And that gives them a Jewish ethnic identity, because that's the whole point of Mandela and King Ansell. And that is the distinction between Jews as a group and Muslims as a group. Actually,
the decision is anyway not representative of English law, is it? 6.4 is contrary to Rogers.
That is contrary to Rogers.
Contrary to Rogers. And therefore it might be said it overlooks the fact that Mr. Krarup's statements in the Danish Parliament might well have been taken to be directed at foreigners, non-Danes directly.
Absolutely, absolutely.
Flooding into Denmark, he said.
Yes. The next significant international law instrument is the UN Convention on the Rights of the Child. This is at volume 13 of the Authorities Bundle, tab 87. And starting with Article 2, states parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents' or legal guardians' race, colour, sex, language, religion, political or other opinion, national, ethnic or social origin, property, disability, birth or other status. So specific recognition of the need to protect the child against discrimination based on his mother's status as well as on the child's status. Then Article 3, in all actions concerning children, whether undertaken by public or private societal welfare institutions, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration. Now, this is a point I'm going to return to when we come to the question of justification, because my submission is going to be that regardless of any question on direct discrimination, this school simply cannot get home on indirect discrimination because the interests of the child, the best interests of the child, have been wholly disregarded when the school formulated its aim and decided what it was doing was proportionate. Completely disregarded what should have been a primary consideration. Then Article 28. States parties recognise the right of the child to education, and with a view to achieving this right progressively and on the basis of equal opportunity, they shall in particular, and B is encourage the development of different forms of secondary education, including general and vocational education, make them available and accessible to every child, and take appropriate measures such as the introduction of free education offering financial assistance in cases of need. And we submit that these provisions make it very clear why Parliament didn't include an exception for any form of race discrimination in relation to access to a school. It would have been clearly contrary to the provisions of this convention for it to have done so. And that's why we submit that a legislative option may well not be an option on the facts of this case.
Well, I think if we're being pedantic, doesn't this convention post-date the 76 Act?
Well, lady, that may well be right, yes. But of course, the Human Rights Convention was in force at that time, and if we can just turn to that briefly.
But I'm sorry, I mean, doesn't this prove too much? I mean, on any showing, you accept you can have faith-based schools that prefer children who go to synagogue, whatever it may be. I mean, how does this live with that?
Well, we submit that it's a powerful indication that you can't have race-based schools.
What's it got to say about, why does it say anything about race as opposed to anything else?
Well,
you can have religious based, so
can I just show a couple of more points before we engage on that? I want to go to the European Convention on Human Rights. Sorry, I've lost my reference to it. If somebody could let me know where it is, that would be wonderful. It's volume 9. Tab 72.
Look at everything. Sorry, 72, yeah.
Tab 72. And the first protocol is, it's page 24, Article 2 of the first protocol, the right to education. No person shall be denied the right to education. That is the dominant right, which is the right of the child. In the exercise of any functions which it assumes in relation to education and to teaching, the state shall respect the right of parents to ensure such education and teaching in conformity with their own religious and philosophical convictions. So we rely on this, of course, for the point that the primary focus is on the right of the child to education and the right of the parent to educate the child in accordance with the parent's religious convictions and not the convictions of a third party. And that, of course, must be read together with Article 14, preventing discrimination. But my Lord Brown asked me, well, what's this got to do with race? And the answer is, because of very strong authority by the European Court of Human Rights, that you cannot justify race discrimination in relation to a child's access to education. That is not capable of being justified. And that is the case of DH, the Roma case. That is at volume 2 of the authorities bundle, at tab 20. So this concerned discrimination against Roma children who were disproportionately being placed in special schools in the Czech Republic. And if we go to page 117 of the report, paragraph 176, discrimination on account of inter alia a person's ethnic origin is a form of racial discrimination. Racial discrimination is a particularly invidious kind of discrimination, and in view of its perilous consequences, requires from the authorities special vigilance and a vigorous reaction. It is for this reason that the authorities must use all available means to combat racism, thereby reinforcing democracy's vision of a society in which diversity is not perceived as a threat, but as a source of enrichment. The Court has also held that no difference in treatment, which is based exclusively or to a decisive extent on a person's ethnic origin, is capable of being objectively justified in a contemporary democratic society built on the principles of pluralism and respect for different cultures.
Of course, that statement is being made in the context of a provision which allows justification of both direct and indirect discrimination.
That is correct.
And of course, we don't allow any justification for direct discrimination.
That is correct. That is correct. But except where there are specific statutory exceptions. Yeah. But that is a very powerful indication. And in the context of access to education, discrimination in access to education, of the grave barrier in the way of anybody seeking to justify discrimination based to a decisive extent on ethnicity, and we would submit is an indication that's saying, well, I discriminated on the grounds of ethnicity, but I did it because I believed my religion compelled me to. It would not be a defence. And we submit that these materials are an indication that the Race Relations Act should be broadly and purposively construed to protect children against discrimination based on their descent from a Jewish or non-Jewish mother. Briefly, Lord Panic relied on the Hassan and Chaush against Bulgaria decision. We submit that is of no application, because that is about the internal organisation of a religious organisation for its own religious purposes. It is not about a situation where the manifestation of religious belief interferes with the fundamental rights of another party. And the decision of the House of Lords in Williamson, in my submission, gives the authoritative explanation of how you deal with that type of a situation. Now, can I deal very briefly, before I move to indirect discrimination, with section 3.4, Lord Panic sought, perhaps rather faintly, to mount an alternative case based on section 3.4, saying that you weren't comparing like with like in this case. He accepted, I think, that this would not improve his case, because if the factor relied on as constituting a material difference between M and a comparative child was in itself discriminatory, that it couldn't provide a defence to the direct discrimination claim. Now, that's obviously correct, and it's derived from the decision in James and Eastleigh Borough Council, it most clearly set out that principle. But it's worth taking another look at, James and Eastleigh is at tab 28 of volume 3. Now, the reason this is of some interest is because James and Eastleigh is also a situation where you have a discriminator saying, it's not on the grounds of your sex, it's on the ground that you're not of pensionable age. That's why you don't get into the swimming pool free. And it's only when you analyse the criterion that you see that the criterion itself involves discrimination. So similarly, the school says here, it's not on the grounds of your ethnic origin, it's on the grounds of your religious status. But when you analyse the criterion of religious status, you see that it in itself discriminates on grounds of ethnic origin. And it's interesting that reliance was placed in this case on section 5.3 of the Sex Discrimination Act, which is the equivalent of section 3.4, and it was argued that a woman of pensionable age, i.e. age 60, was not comparable with a man of age 60. There was a material difference between them, namely, she was of pensionable age and he was not, and that therefore you couldn't compare their cases. Same argument that's set out in Lord Panic's case for saying you can't compare M with a child who is halakhically Jewish. He says, well, their circumstances are not comparable. But Lord Bridge disposed of that argument at page 766. At C, he said the Court of Appeal detected and properly criticised the error made by the trial judge in the application of section 29, that's the services provision in the Sex Discrimination Act, and that he sought to define the section of the public to whom services were provided by the council in terms which are themselves discriminatory in terms of gender. But they fell into the same error themselves in making the comparisons necessary under section 1. Section 5.3 requires that in comparing the cases of persons of different sex under section 1.1, the relevant circumstances must be the same. Because pensionable age is itself discriminatory, it cannot be treated as a relevant circumstance in making a comparison for the purpose of section 1, any more than it can be used to define a section of the public under section 29. It's only by wrongly treating pensionable age as a relevant circumstance under 5.3 that it is possible to arrive at the conclusion that the provision of facilities on favourable terms to persons of pensionable age does not involve direct discrimination, but may involve indirect. On a proper application of 5.3, the relevant circumstance, which was the same here, for the purpose of comparing the treatment of the plaintiff and his wife, was that they were both aged 61. So, my lords, my lady, I now turn to the question of indirect discrimination. And we submit that there are 2 points which are immediately striking about the way in which indirect discrimination has been dealt with by Lord Panic. The first is that he declined to make any oral submissions on one of the points that appears in his printed case, and that is the argument that there was no indirect discrimination against M because M was to be regarded as a member of the advantaged group. Lord Panic's argument is M is ethnically Jewish, and therefore he is not a victim of a criterion which places those who are not ethnically Jewish at a significant disadvantage. Now, we submit it's quite obvious why Lord Panic declined to elaborate orally on that submission. Well, he says he didn't have time, but my lord, my respect for Lord Panic is such that I doubt whether he would appear before the Supreme Court and decline to make a point he thought was good because of a lack of time. But it's not simply that the point is bad. It's that when one considers the point, it undermines his case on direct discrimination, because the argument is actually the inevitable outcome of his submission that we were just looking at paragraph 43.1, because his argument under 43.1 is objectively this child is ethnically Jewish, and therefore there is not discrimination on grounds of the child's ethnic origins. But of course, this child is a child of mixed ethnic origins. He has a father of Jewish ethnic origins and a mother who is Italian and who converted to Judaism. Her conversion is not regarded as having any validity by the chief rabbi, so the chief rabbi perceives him as of mixed ethnic origins. And his ethnic origins are not the same as those of a child who has two parents who were born Jewish. They are different. And it is that difference which is the reason for his disadvantage. So I submit the reason Lord Panic ran out of time on this submission is because when one considers it, not only is it a bad point in relation to indirect discrimination, and one does step back startled at the notion that M is in the advantaged class, but it shows what's wrong with his case on direct. The second striking point is this, that Lord Panic, and indeed I don't believe any of the interveners, chose not to show to this court any legal authority at all on the proper legal test for establishing indirect discrimination. And we submit that the reason for that is that the test for justification, which Lord Panic has urged upon this court, is in fact wrong in law. What Lord Panic has done is simply to say, well, the school has a legitimate aim to give priority to those who are members of its faith. And once you accept that that's a legitimate aim, the only way it can meet that aim is by giving priority to members of its faith. End of story. Now, there's something very wrong with that, and what is very wrong with that, as we shall see in a moment when we look at the authorities, is that it leaves out of account a large chunk of the legal test for proportionality. Because what that legal test requires is not simply there's a legitimate aim and this is the only way I can reach it. It requires a number of factors. First of all, the court must consider whether the aim that's being pursued is of sufficient importance to justify interfering with the fundamental rights of another party. Secondly, the court is required to undertake a critical evaluation of the extent of the adverse effect of the policy on the disadvantaged individuals. And finally and crucially, the court is required to weigh the adverse effect upon those who suffer as a result of the discriminatory condition against the need of the discriminator to maintain the condition. It's not enough just to say this is my aim and this is the only way I can meet it. The other side of the equation has to be considered. What is the effect of this on the children? And is the need to maintain the condition so great that it outweighs their rights? And all of that is disregarded. Indeed, the submission appeared to be, this is a religious aim, the court shouldn't examine it, that's the end of the case. We submit that is simply wrong in law. And in fact, as I shall show the court in a moment, there is no evidence at all that could, on any basis, enable the school to show that it had proved a defence of justification. And of course, the burden of proof is on the school to show that these conditions are satisfied. And there is simply no evidence that the school even ever considered the possibility that what it was doing might have an adverse impact on particular ethnic groups, that it certainly never considered the extent of the disadvantage to those groups, never considered whether it really needed to maintain this condition, whether its aim was so important it should be continued, notwithstanding the adverse impact. Never considered at all by the school, not even ex post facto, and therefore we submit no basis for a finding of justification. So the legal framework for indirect discrimination is at section 1(1) capital A of the Race Relations Act. That's in bundle A9. We ought to probably just briefly have it open while we go through the various elements. This is tab 73 in bundle A9.
There's section 1(1)B. It's still in force, and of course it applies to those bits to which section 1(1) big A doesn't apply.
That's correct.
But does it also apply, almost with a superabundance of tests of indirect discrimination, to the cases to which section 1(1) big A does apply?
No. The reason it doesn't is because section 1(1)C says that it doesn't. Now, of course, the position is that 11B is the original test.
Yeah.
11A is introduced because of the race directive. We know from the race directive that it was unlawful for a state to reduce the level of protection against discrimination when implementing that directive. There's a non-derogation provision in the race directive. Therefore, 11A must be at least as favourable as 11B. So there cannot ever be a case that wouldn't succeed under 11A that would have succeeded under 11B.
Oh, yes, I'm sure that's right. Yes.
No, the Secretary of State argued to the contrary in the Court of Appeal. That was the argument which Lord Justice said he found surprising. Anyway, that's not being maintained. So the first question, if we look at 11A, is what is the provision, criterion or practice which is being applied? And we know the answer to that. The answer is it's paragraphs 1.1, 1.2 of the admissions policy, which are in the terms that we have seen. The second is that must be a criterion which we can see, which he applies or would apply equally to persons not of the same race or ethnic or national origins. That's the second element of indirect discrimination. And that is why you cannot have a case which is both direct and indirect discrimination. Because by definition, if a criterion is unequally applied, you're talking about less favourable treatment, and that is 11A and unjustifiable. So that's one of the reasons why we say this is direct and not indirect discrimination, because we say this is not a criterion that is applied equally to those of M's mixed ethnic group and those who are of entirely Jewish ethnic origins. It is applied unequally to those groups. Somebody, both of whose parents were of Jewish ethnic origins, would always get a place at JFS. But somebody like M, whose mother was of Italian ethnic origins, will not get a place at JFS unless the conversion of his mother is accepted as valid by the chief rabbi. So that's why we say the criterion not equally applied, direct, not indirect. The next issue under 11A is that the criterion puts or would put persons of the same race or ethnic or national origins as that other at a particular disadvantage when compared with other persons, and we say plainly that is correct. Those who are either of mixed ethnic origins or non-Jewish ethnic origins are at a disadvantage compared with those who are of Jewish ethnic origins. The next is that it puts M at that disadvantage. Again, we say plainly yes. And then we come on to the final question, which he cannot show, so the burden of proof is on the school, to be a proportionate means of achieving a legitimate aim. Now, looking first at the legal test for legitimacy of an aim, this is a matter that was addressed by the House of Lords in Mandler. If we go back to A4, tab 35. The facts of Mandler, of course, are that the child is not allowed to wear his turban in the school. And that is indirectly discriminatory against Sikhs, because Sikhs have a religious and ethnic requirement to wear a turban. And at page 566, Lord Fraser considers the question of justifiability. This is, of course, the test under the old section 11B, but plainly, for the reasons we've just explored, cannot be cannot be more generous than the test under 11A. So at F, an attempted justification of the no turban rule, which requires more serious consideration, was that the respondent sought to run a Christian school, accepting pupils of all religions and races, and that he objected to the turban on the ground that it was an outward manifestation of a non-Christian faith. In other words, a religious aim there being put forward by the school was the legitimate aim. Indeed, he regarded it as amounting to a challenge to that faith. I have much sympathy with the respondent on this part of the case, and I would have been glad to find that the rule was justifiable within the meaning of the statute if I could have done so. But in my opinion, that is impossible. The onus under paragraph 2 is on the respondent to show that the condition he seeks to apply is not indeed a necessary condition, but that it is in all circumstances justifiable irrespective of the colour, race, nationality or ethnic or national origins of the person to whom it's applied. That is to say, that it is justifiable without regard to the ethnic origins of that person. In this case, the principal justification on which the respondent relies is that the turban is objectionable just because it is a manifestation of the second appellant's ethnic origins. That is not, in my view, a justification which is admissible under paragraph 2. The kind of justification that might fall within that provision would be one based on public health, and he gives an example of a chocolate factory where you're not allowed to wear a beard for hygienic reasons. And so, statement by Lord Fraser there that a legitimate aim, which is in itself connected with the ethnic origins of the individual, is incapable of being a legitimate aim for the purposes of this provision.
It moves from objections on the ground it was an manifestation of a non-Christian faith to manifestation of ethnic origins.
Yes, it's interesting. And that, in my submission, is also of some interest on my direct discrimination case, because it shows the extent to which Lord Fraser, where you had a group like Sikhs who were an ethnic group and where religion was an inescapable part of their cultural identity, was not drawing a distinction between religion and ethnicity.
If the headmaster had said it's a secular school and we don't want any religious manifestations at all, would that have been, I mean, whether it stood up or not, at least one which didn't, which applied irrespective of, etc.?
That might be so, yes.
I mean, the Denby school case, one
yes,
consults.
Yes, indeed. I believe this is an issue that Miss Mountford is very familiar with in relation to Sikhs wearing bangles as well at school. But Lord Fraser considered this question again in another case. It was in the case of Orphanos, which is in bundle 5 of the authorities bundles, tab 42. Now, the facts of Orphanos were that Queen Mary College charged higher fees to students who were not resident in an EEC, as it then was, an EEC country, and had not been resident in an EEC country for at least 3 years. And this was held to be indirect discrimination because residence is not direct discrimination but has an indirectly discriminatory effect on non-EEC nationals. So the question then was whether this was justifiable. And this was dealt with at page 772 of the report. At E, we're told that what they were trying to do was to save money. And the method chosen was to concentrate grants on home students and to cease subsidising foreign students. And the justification relied on by the college is at E to F. The fees of home students are subsidised. There's no good reason why the fees of overseas students should be subsidised from public funds. Government cannot afford to subsidise overseas students. Use of fees as a legitimate means of regulating the admission of overseas students has the advantage of reducing public expense. Previous system had resulted in a large increase in numbers and large increase in the cost to British taxpayers, with little relationship between the pattern of these large student numbers and Britain's own long-term priorities. Now, in my submission, there is a similarity between the aim which the school says it is pursuing in this case and the aim analysed here. Because essentially what's being said is we have limited resources and we wish to target our resources on our home students. We wish to give them priority over the overseas students. And one can understand why a college might want to do that. And what is said then is these statements show that the main motive for introducing the residence requirement was economy, but the economy was to be affected at the expense of foreign students. That may have been a perfectly reasonable and justifiable policy for the British government to adopt, but in my opinion, the college, on whom the onus lies, has not been able to justify the requirement without having regard to the nationality of the applicants, at whose expense the policy was carried into effect. There is then a reference again to the Panesar case and to Mandler. And at the top of 773, the justification there was purely a matter of public health and nothing whatever to do with racial grounds. But in the present case, the discrimination is in accordance with a policy directed against persons who are not ordinarily resident in the EEC area. Ordinary residence is, in my view, so closely related to their nationality that the discrimination cannot be justified irrespective of nationality. So now, assuming Lord Panic is right, and this is a religious and not a racial form of treatment, so we're not in the boundary of direct discrimination, there is in my submission, in any event, a very close relationship between the religious test that is devised and the ethnic origins of the students. Because in the overwhelming majority of cases, those who are of Jewish ethnic origins will qualify, those who are not or who are of mixed ethnic origins will not. The overwhelming majority of cases. And the assertion, well, we want to give priority to the former group, is in my submission falling foul of the analysis of Lord Fraser here, that that is so closely connected with the ethnic origins of the student that it's incapable of constituting justification. Now, a slightly different approach to this type of problem was taken by Lord Justice Mummery in the Elias case. And it doesn't appear, from what I've seen from the report, that this argument, the Orphanos and Mandler argument, was actually relied on before Lord Justice Mummery. If I can just turn to it, it's at tab 6, or if it was, he doesn't refer to it. It's at tab 6, volume 6 of the Authorities Bundles, tab 55. Miss Mountfield tells me it was, but he certainly doesn't refer to it in the judgment. This is the case.
Did you say 65?
Yes, but not on this one.
It's 55 and
tab 55, volume
55,
6.
Yes.
This is the case concerning the Japanese prisoners of war and the ex gratia compensation scheme which the government established for their assistance, where to be eligible for compensation you had to show close links with the United Kingdom, and the criterion that was adopted for demonstrating that was that you had to show that your parents or grandparents had been born in the United Kingdom. And this was successfully argued to be indirectly discriminatory on racial grounds. And Lord Justice Mummery dealt with the question of the legitimacy of the aim. If we go to, not legitimacy of the aim, but justification at paragraph 160, he accepted that the aim was legitimate in this case, and there is no discussion in his consideration of the legitimacy of the aim of the passages I've just shown to the court, either from Orphanos or from Mandler.
So where's paragraph what?
160. Paragraph 160.
160.
160?
Yes, if we go to paragraph 160, this is the way he analyses it, which is slightly different. He says, although the birth link criteria are not direct discrimination in the form of treatment on racial grounds, as they relate expressly to place of birth, they are in substance very closely related to treatment on racial grounds. This is because it's self-evident that the overwhelming proportion of applicants born in the UK or whose parents or grandparents were born in the UK have UK national origins, as compared with the overwhelming proportion of applicants not born in the UK who do not have UK national origins. Even though UK national origins are not formally specified in the birth link criteria, Mrs. Elias's exclusion from the compensation scheme is in substance very closely related to her non-UK national origins. It is that exclusion that has to be objectively justified. A stringent standard of scrutiny of the claim justification is appropriate because the discrimination, though indirect in form, is so closely related in substance to the direct form of discrimination on grounds of national origins, which can never be justified. And indeed, I'm wrong. What he does refer to Orphanos. It's in the next paragraph. But what he says is that I agree with the judge that the speech of Lord Fraser in Orphanos supports the stringent standard of scrutiny in seeking to justify indirect discrimination which is closely related to racial grounds. Now, what's slightly odd about that is, in fact, Lord Fraser doesn't say you have to have a stringent standard of scrutiny. He says it's impossible to justify race discrimination, indirect race discrimination, where the legitimate aim is closely related to racial grounds. He says it in both Orphanos and in Mandler. So there is a slight mismatch between the approach that's taken by Lord Justice Mummery and the approach that's taken by Lord Fraser. But Lord Fraser certainly says it can't in principle be a legitimate aim. That's the approach the Court of Appeal followed in this case. But the alternative approach, which Lord Justice Mummery suggests, is, well, even if technically it may be justifiable, you need to apply a very stringent standard of scrutiny, given the close relationship between the legitimate aim and prohibited grounds. So then coming to the legal test for proportionality, the starting point in race discrimination cases is the old case of Hampson and the Department of Education and Science. This is in tab 3 of the extra bundle of authorities that we handed up yesterday. This is the decision of the Court of Appeal in Hampson. The case went then to the House of Lords on the other point in the case, which was the proper scope of Section 41 to the Race Relations Act, the exception for acts done under a statutory authority, and it was reversed. The decision of the Court of Appeal in relation to Section 41 was reversed. But this question, the question of the proper test for justification of indirect discrimination under the Race Relations Act, was not appealed and has subsequently been regarded as a classic source, certainly a good starting point for considering the right test for justification of race discrimination. And the relevant passages at page 191, Lord Justice Balcombe at F. In my judgment, justifiable requires an objective balance between the discriminatory effect of the condition and the reasonable needs of the party who applies the condition. And he then says that that is supported by Rennie. So there is the first indication in this authority that there are two sides to the equation. It's not enough just to say, well, this is my aim, it's legitimate, and I need to do this to achieve it. Thank you very much, I win. There are two sides to the equation. The first is that you have to look at the aim the employer is, or in this case the school is pursuing, and evaluate the school's need to pursue that aim. The second thing you need to do is to consider the extent of the discriminatory effect of the policy. That, of course, has to be evaluated, and then it must be weighed against the reasonable needs of the discriminator. So both sides of the equation have to be properly addressed in order for a result to be obtained on the proportionality test. And later cases have emphasised this. If we turn now to volume 3 of the authorities bundle, this is the case of Huang. Tab 76. That can't be right. Hang on. Maybe it's 26. Yes, it's tab 26, volume 3. Paragraph 19, under the heading proportionality. In De Freitas.
Sorry, can you just tell me the paragraph again?
Sorry, paragraph 19.
Thank you.
Page 187. Proportionality.
Yeah.
In De Freitas, the Privy Council defined the questions generally to be asked in deciding whether a measure is proportionate. Whether, one, the legislative objective, here of course it's not a legislative objective, but whether the objective is sufficiently important to justify limiting a fundamental right. Two, whether the measures designed to meet the legislative objective are rationally connected to it. And three, that the means used to impair the right or freedom are no more than is necessary to accomplish the objective. This formulation has been widely cited and applied, but counsel for the applicants with the support of liberty suggested that the formulation was deficient in omitting reference to an overriding requirement which featured in the judgment of Chief Justice Dixon in Oakes, from which this approach to proportionality derives. This feature is the need to balance the interests of society with those of individuals and groups. This is indeed an aspect which should never be overlooked or discounted. House recognised as much in Rasgar, when having suggested a series of questions which an adjudicator would have to ask and answer in deciding a convention question, it said that the judgment on proportionality must always involve the striking of a fair balance between the rights of the individual and the interests of the community, which is inherent in the whole of the convention. The severity and consequences of the interference will call for careful assessment at this stage. And we submit that Lord Pannick has, in effect, invited the court to apply the de Freitas test, ignoring the additional vital requirement emphasised here by the House of Lords in Huang. And we see the proper analysis in my submission in the decision of the Court of Appeal in Allenby. This is volume 1, this is a sex discrimination case. Volume 1, tab 2.
Can I just see where we're going here? I mean, I know you say it's direct discrimination, but if it's indirect discrimination, I mean, does this take you to a point where conceivably the court could, so to speak, maintain its essential test of entry, but just make exceptions in particular individual singular cases?
Well, Lord, it's clearly not a matter for this court to seek to dictate to the school what its entry criteria should be. If we are looking at a case of indirect and not direct discrimination, there are various admissions criteria which could be adopted by the school which would have a far less severe impact on children. Perhaps the most obvious, and this of course would not be possible under direct discrimination where you have to have a faith or practice criterion, but would be possible if this is a case of indirect discrimination, would be a criterion that said anybody who is recognised as being of Jewish status, ex hypothesi, that's not racial, recognised as being of Jewish status by any of the Jewish religious denominations in the United Kingdom, Orthodox, Masorti, Reform or Liberal. Now, if the school were to adopt that as an entry criterion, the result, in effect, would be that virtually every child who had any sort of real need for a Jewish education would be unable to get it, because it would encompass all children who had a Jewish father and all children who had a Jewish mother converted by any of the religious movements. And therefore, in reality, any 11-year-old child being brought up in any sort of a Jewish environment who was likely to be practicing any form of Judaism. So the adverse impact in terms of the right of the child and of the parent to access to education, in terms of the parent's religious convictions and the needs of the child, would be much, much less than the criterion adopted by the school. So that's one possibility. I'm not suggesting it's the only one, but
I'm having great difficulty in the practical aspect of yes. This exercise, because this is a school which people go to learn Orthodox Judaism. And one of the tenets of Orthodox Judaism is it's absolutely vital that those who are Orthodox Jews follow the faith. It's not vital at all for those who are not Orthodox Jews. And so they would say there's every justification from the viewpoint of the needs of the pupils for our policy.
Yes, Lord, I'm going to come on to the facts, of course, in a moment when we've looked at the law, but my submission that the fallacy in that is that it is entirely from the perspective of the chief rabbi. And what it entirely ignores is the actual convictions and needs of the children and their parents. because it says, I, the third party, the chief rabbi, don't think that you are under an obligation to learn about the Jewish faith, so you're not a priority for me. But what it ignores is two facts. Firstly, there is no alternative. There is no secondary school where these children can get a Jewish education. This is their only choice. And secondly, these children themselves have a very great need for a Jewish education. And I hope that your Lordship will have had a look at the witness statement of M, which eloquently explains just how important it was to him to be educated in a Jewish environment. He suffered taunting in his primary school when he attended wearing his kippah. He felt unable to express his religious identity in that school. There is no other school in which he can express his Jewish religious identity. And the point that I make is it is inadequate to approach the question of justification only from the viewpoint of the discriminator and to leave out of account the other side of the equation, which is the adverse effect on those who suffer the consequences. And it may be that the discriminator has to do something different in order to ensure that that adverse effect is mitigated. And my submission goes further, because I say that the obligation on the discriminator is greater in this regard because this is a state-funded school. This is not a private school operated by one group for its own purposes and funded by them. This is a school funded by the taxpayer for the benefit of the public, and the school, therefore, is under a specific statutory duty under Section 71 of the Race Relations Act to promote equality of opportunity and eliminate race discrimination. And we submit it is wholly inadequate just to look at this from the perspective of the religious priorities of the chief rabbi and to ignore the impact on excluded children.
It's the religious priorities of the religion, isn't it? And here is a school which children want to go to because they say it's very important that we should be able to follow this religion. And that religion would say it's much more important for a Jew to be able to follow the religion than for somebody who's not a Jew. And our policy is designed to give priority to the Jews.
Yes.
So that is conferring the maximum benefit on the pupils. It's not just for our benefit.
It's conferring the benefit on the pupils from the perspective of the chief rabbi, but not from the perspective of the pupils.
But isn't that what their parents would expect as well?
Well, no, my lord, because, of course, I'm going to come on to the particular facts. And one of the important points here is that JFS is not a school which serves the Orthodox religious community. JFS is a school which has always, and does now, serve the whole of the Jewish community. Many who are unaffiliated, many liberal, many reform, many very committed reform and Masorti Jews send their children to JFS. It's always taken pride in the fact that it's a school for the whole of the Jewish community. And therefore the religious convictions, and of course the effect of this policy is to override the religious convictions of the parents, because parents who are atheist or indeed practicing Christians can get their children into JFS if they have the right birth line, but children whose parents are very committed Jews cannot, if they cannot satisfy the test. Now, the point that my Lord Phillips put to me takes one back to my primary argument about why this is direct discrimination. Because, of course, if your aim is to give priority to the Jews and you define the Jews by descent, you cannot detach that from direct discrimination. And either it falls foul of the direct discrimination test or it falls foul of the Orphanos and Mandela principle, it's not a legitimate aim, which is where the Court of Appeal got to. But we're now a little bit further down the line, assuming that those lines of argument are wrong. And it's at that stage that I submit the school can't just say, well, the chief rabbi thinks that it's important that those that he regards as Jewish get this education and they should be prioritised. That's what they want to do. But they also have a duty, under the Race Relations Act, a duty to take into account the effect of that on the excluded children who are nonetheless part of the Jewish faith community.
Can I ask, could that be dealt with conceivably by some sort of safety valve mechanism? In other words, could you contemplate that instead of 100% priority to the Orthodox Jewish belief that everyone who's an Orthodox Jew must be educated in Orthodox Judaism, whether they're interested or not in that, you had a system where a certain quota was reserved for other people to cater for hard cases, to cater for cases where there was real risk of actually aggravating relationships between the different branches of Judaism.
On the assumption that this is not direct discrimination, which is, of course, where we're at.
But you could have a sort of quota system.
There are ranges of different options that the school could adopt to cater for this problem. What we submit they cannot do is simply to ignore the problem. And what is that? I'm going to show the evidence in a moment. What has happened in this case is that there's never been any consideration of this question at all. It just hasn't been addressed. The whole of that side of the equation has been completely disregarded. And that's why I said, beginning my submission on indirect discrimination, that there is no basis on which their defence can succeed.
I mean, they could say, could they, that if your mother's been head of English for 20 years at the school, then you're in. Yes. I mean, that's the sort of level of particularity which they could deal with.
They could do that. They could do that. And remember, they've got to comply with the admissions code. So there are other issues about compliance. There's the sorts of criteria that comply with the admissions code. But there are a variety of different means by which they can address the problem. But what we submit they can't do is ignore the problem. And it's not, with respect for this court, to seek to work out what the solution is. But all that is significant is that if they haven't even understood that there was a problem and addressed what solutions might be possible, the justification defence necessarily fails. Can I just come to the Allenby case? My Lord, I'm not going to finish by lunchtime, and if I might perhaps have 20 minutes after lunch, that would be greatly appreciated.
Well, I think you must discuss with those who have still to bat how long they need, so there's a fair apportionment. But
I don't want to get into a tit for tat, but they did somewhat exceed their own estimates and everything. But anyway, Allenby, paragraph 24.
24, it's tab 4, tab 2.
Allenby is tab 2.
Sorry, no.
Volume 1.
Sorry, 24, did you say?
Paragraph 24.
Thank you.
There is a reference to the Hampson test. Then going on to paragraph 27, the major error, which by itself vitiates the decision, is that nowhere, either in terms or in substance, did the tribunal seek to weigh the justification against its discriminatory effect. On the contrary, by accepting that any decision taken for sound business reasons would inevitably affect one group more than another group, fell into the same error as the appeal tribunal in Brooke and disabled itself from making the comparison. Secondly, the tribunal accepted uncritically the college's reasons for the dismissals, and that there are points about that. And then at paragraph 29, in this situation, it's not enough that the tribunal should have posed, as they did, the statutory question whether the decision taken by the college was justifiable irrespective of the sex of the persons or persons to whom it was applied. In what are extended reasons running to 15 pages, there has to be some evidence that the tribunal understood the process by which a now formidable body of authority requires the task of answering the question to be carried out, and some evidence that it has in fact carried it out. Once a finding of a condition having a disparate and adverse impact on women had been made, what was required was, at the minimum, a critical evaluation of whether the college's reasons demonstrated a real need to dismiss the applicant. If there was such a need, consideration of the seriousness of the disparate impact of the dismissal on women, including the applicant, and an evaluation of whether the former were sufficient to outweigh the latter. There is no sign of this process in tribunal's extended reasons. No recognition that if the aim of dismissal was itself discriminatory and so forth, it could never afford justification. That's the Orphanos principle again. But the key point I draw from that is that at the minimum, there must be a critical evaluation, both of the extent of the discriminator's need and of the extent of the adverse effect that it has on the disadvantaged group, and then a balancing of one against the other. And we submit that not only has that task has simply never been undertaken at all in this case.
Well, I thought, actually, I'm looking at paragraph 184 of Mr. Justice Munby's decision.
Absolutely, my lord.
At page 73, he does refer to these authorities, doesn't he?
Yes, but what's fascinating, my lord, about Mr. Justice Mumby's judgment is he identifies that there's a need to consider the impact on the disadvantaged group, and then never discusses it.
Oh.
It's quite strange.
Was it?
Can I come back to this at 2 o'clock and I'll have the exact paragraph? But what he did, Mr. Justice Mumby, was that he flagged up that this was an issue, but then there was no discussion of it at all in the judgment and no attempt to weigh the one against the other.
I don't want to detain you, but I just thought I'd mention
yes.
that.
Well, I mean, of course, I cited these authorities to him, but there is just no discussion of the question at all in his judgment. Now, that then brings us to the question of what is the aim in this case. And we do submit that the case that's now being advanced by the school in terms of the aim and the justification, in fact, bears little relation to that which was originally put forward by the school and supported in its evidence. If we go first back to the questionnaire, that's part 3 of the appendix, page 1183. And of course, this is the statutory questionnaire. We asked the question 11, if it is accepted that the admissions policy does discriminate indirectly on grounds of race, but contended that such discrimination is justified and thus lawful, please set out in full the justification relied upon and provide any relevant documentation underpinning that justification. And the response is at page 1201. If, which is denied, there was indirect discrimination, it would be justified. JFS's admission criteria seek to maintain the school's religious ethos. If they were indirectly discriminatory, but are a proportionate means of achieving a legitimate aim. No further reference there. Then simply the point is then made that there would be other faith schools which might also be indirect discriminatory, but no one suggests such indirect discrimination is unlawful. And over the page, even if JFS's admission criteria were indirectly discriminatory, there's no ground on which to suggest the admissions policy for JFS is to be treated differently from that of other faith schools. So the aim of giving priority to members of the faith is not mentioned, and neither is there any reference to the religious obligation of non-observant children to study Judaism. It doesn't feature in the case of the school at all. Evidence was then put in by the school to support its justification defence. And of course, as I've already said, the onus is on the school to prove its justification defence. And this is the evidence of Arnold Wagner. It's part 2 of the appendix. Page 525. Paragraphs 25 to 29. So starting at the bottom of page 530, it's the view of JFS that paragraph 1.1 does not raise issues of race but is a religious issue. The very fact that JFS has always seen it as a religious issue and a matter of religious law meant that as the admissions committee we did not consider the impact that the admissions policy might have under Section 71 of the Race Relations Act 1976. Very important admission there. And the foundation of the finding by Mr. Justice Mummery that there was a breach of the duty under Section 71. Also significant, we say, in terms of the justification for indirect discrimination, because it is an admission that no consideration of the adverse impact of this policy on disadvantaged groups was ever undertaken by the school.
It's my fault. What page are we looking at?
I beg your pardon. Page 530 at appendix part 2.
Thank you.
Then at 26, he says again it's a religious issue and not a racial issue. And then at 27, as a result of 1.1 being a religious issue, I am advised that there is no direct race discrimination. Furthermore, if it is considered to be indirectly discriminatory, which I do not believe it is plain that the purpose of 1.1 of the admissions policy is to comply with the aims and objectives set out in the instrument of government, and as such is a pursuit of a legitimate aim because it is developing the religious character of JFS in accordance with the principles of Orthodox Judaism. So that is the aim identified. Again, no reference to the need to prioritise members of the faith and so forth. In giving priority to children who are halakhically Jewish, as recognised by the Office of the Chief Rabbi, JFS is adhering to the principles of Orthodox Judaism. And then he says he's read the adjudicator's decision and agrees with the comments of the adjudicator. So if we go to the adjudicator, on which he relies, that's part 1 of the appendix, in the core volume, page 282. And it's paragraph 14. And he accepts that there is a disparate impact, and then he says, however, the policy, in my opinion, does seek to pursue a legitimate aim, namely, the preservation of an ethos at the school which reflects Orthodox Jewish principles. Now, that is a passage which, of course, Mr. Wagner has said in his witness statement he is accepting, and that is a different aim from the aim now being advanced, to preserve the ethos of the school. That would also accord with the instrument of government. Those principles of Jewish law recognise Jewishness passes through the maternal line. That appears to me to be a religious matter, given that the aim of the policy is to ensure those who are Jewish by reference to Jewish law are admitted to the school. It's proportionate to adopt a policy which, even if it puts ethnically non-Jewish persons at disadvantage, seeks to ensure those children are given priority are Jewish, in accordance with Orthodox law. I regard the justification as compelling. The legitimate aim being pursued is to seek to ensure those children who are Jewish are admitted to the school. Alternatives wouldn't achieve it, relate to a different aim, and therefore he upholds it. That is the entirety of the evidence that was submitted by the school in support of its justification defence. That is it. And that is why I made the submission that there is simply no consideration at all of the matters identified in Huang and Allenby as being critical. But the notion of it being a religious obligation to draw non-observant children towards the faith is strikingly absent from the evidence of the school and from the observations of the adjudicator, which of course followed from submissions made to the adjudicator by the school. That notion did not derive from any material or argument put forward by the school. That notion first surfaced in the witness statement of Diane Gelly, submitted on behalf of the United Synagogue, and formed the basis of a submission made on behalf of the United Synagogue by Mr. Jaffe. At that time, I said, well, is this a justification which is being adopted by the school? Because it's different from the justification that the school has always maintained, and if this is being adopted by the school, we would want the opportunity to put in evidence about it. And the response of counsel for the school was that they were not seeking to alter the basis of their defence to the claim. What we now see is that this argument about the need to draw children to the school has taken centre stage, particularly as Lord Panic has moved from representing the United Synagogue to representing the school. And indeed is now put in such extreme terms that it is suggested, and it was stated by Lord Panic, that applying a practice test would be incompatible with the principles of Orthodox Judaism, because it was said it's fundamental to Orthodox Judaism that non-observant children should be drawn towards practice, so that a practice test would be incompatible with Orthodox Judaism. Now, my lords, with great respect to Lord Panic, that is demonstrably incorrect. And the reason I say that is because there are a number of Orthodox Jewish schools which have for many years applied as their entry criteria a combination of a Jewish status test and an Orthodox religious practice test.
Do we have evidence to that in the papers?
We do, my lord. We do. Now, I don't know if you want it now. I can give it to you now very quickly.
Briefest reference would be helpful.
Let me just show you one example. Appendix Part 3. Page 1373. These are the entry criteria for the Hasmonean School in North London, an Orthodox Jewish school, not under the auspices of the chief rabbi, but under another Orthodox religious authority. And these are its entry criteria for 2008. In order to be admitted to the school, a child must be Jewish according to halakha and observe and practice Orthodox Jewish traditions and practices, as set out in B2 hereunder. And at B, they say admission will only be given to the child of parents who, 1, have a genuine desire for Orthodox Jewish schooling, and 2, observe the Sabbath and holy days, adhere to the dietary laws, and maintain active membership of participation in an Orthodox synagogue, such synagogue to be one recognised as such by the rabbis of the Jewish secondary schools movement. And that is just one example. If I can give your lordship some page references, you will see similar examples in Part 3 of the appendix at 1348, 1353, 1363, 1369, 1373, 1380, 1383, 1400-1 and 1406. So, my lords, we submit that the evidence is simply inconsistent with the submission that it is necessary for an Orthodox Jewish school to apply a test which is not a practice test. And that, indeed, the submissions that have been made about the practical difficulties of applying such a test, and your lordships are aware of my objection to the evidence put in on that. The reason for my objection is simply this, that there is nothing new about Orthodox Jewish schools applying a practice test. They've been doing it for years, and it is difficult to understand why suddenly it becomes intrusive and practically so difficult when there is nothing new about it.
Well,
that might be a
could I mention that I'm getting concerned now about whether I'm going to be given adequate time to reply. My friend has some way to go. There are 2 other representatives. Could I be ensured, please, by then, an hour and a quarter for my reply? Hope that's reasonable.
Could you sort this out during the adjournment, or try to?
You ran over your collective time. No, I'm not talking. You ran over. They